If you are watching this video, chances are you have already spent months preparing for standardized tests, gathering documents, and dreaming about studying in the United States. You have worked incredibly hard to get this far. But there is one final barrier standing between you and your American education, and it is the one that causes more anxiety than almost anything else in the immigration process: the F-1 visa interview. And here is what makes this moment so critical. You could have perfect grades, a full scholarship, and an acceptance letter from a top university, and still be denied entry to the United States in a matter of minutes. Today, we are going to walk through the entire F-1 visa process from beginning to end, covering not just what the government tells you, but what actually determines whether your application succeeds or fails. Before we get into the step-by-step breakdown, it is essential to understand what the F-1 visa actually represents and why the approval process works the way it does. The F-1 is a non-immigrant student visa, and that word, non-immigrant, is perhaps the most important word you will hear in this entire video. The United States issues this visa under the assumption that you intend to study temporarily and then return to your home country. This is not a pathway to permanent residence. It is not designed to be a stepping stone to immigration, and the moment a consular officer suspects that your true intention is to remain in the United States permanently, your application is in serious jeopardy. This is where the single most common misunderstanding occurs. Many applicants believe that the strength of their academic record or the prestige of their university is what determines approval. While these factors matter, they are not the deciding elements. What the consular officer is really evaluating is whether you have strong ties to your home country and a genuine intent to return after completing your studies. This principle, known as overcoming the presumption of immigrant intent under Section 214B of the Immigration and Nationality Act, is the legal foundation of every F-1 visa decision. If you remember nothing else from this video, remember this: you are presumed to be an intending immigrant until you prove otherwise. Now let us walk through the process in the order you will experience it, starting well before your interview date. The first stage begins the moment you receive your acceptance letter from a U.S. institution. Once accepted, your school will issue a document called the I-20, which is the Certificate of Eligibility for Non-Immigrant Student Status. This document is generated through SEVIS, the Student and Exchange Visitor Information System, which is how the U.S. government tracks international students. Without a valid I-20, you cannot apply for an F-1 visa. And this is where the first potential mistake happens. Some students receive acceptances from multiple universities and delay their decision, not realizing that the I-20 process takes time. If you are admitted to several schools, make your final choice as early as possible so that your I-20 can be issued and processed without last-minute stress. Once you have your I-20 in hand, you must pay the SEVIS fee, which is currently $220 for F-1 students. This payment must be made at least 3 business days before your visa interview, though I strongly recommend paying it immediately upon receiving your I-20. Keep your payment confirmation. You will need it. Many applicants have experienced unnecessary complications at their interview because they could not locate this receipt. The next step is completing the DS-160, the online non-immigrant visa application. This form is long, detailed, and unforgiving of errors. You will be asked about your personal history, travel history, family, education, employment, and your reasons for traveling to the United States. Every answer you provide becomes part of your permanent record, and consular officers will have access to this information during your interview. One of the most damaging things you can do is provide inconsistent information between your DS-160 and what you say in person. If you list your father's occupation one way on the form and describe it differently in the interview, this inconsistency can raise red flags, even if the discrepancy was unintentional. Take your time with this form. Review every entry before submission, and save your confirmation page with the barcode, as you will need to bring this to your interview. After completing the DS-160, you will schedule your visa interview at the U.S. Embassy or consulate in your home country. And this is where timing becomes critical. Visa interviews can be scheduled no earlier than 120 days before your program start date, which is listed on your I-20. However, you cannot enter the United States on an F-1 visa more than 30 days before your program begins. Understanding these two numbers is essential for planning your timeline. Here is where many applicants make a strategic error. They assume that scheduling their interview close to their departure date gives them flexibility. In reality, the opposite is true. If your visa is delayed for administrative processing, which can take weeks or even months in some cases, you may miss the start of your program entirely. Some students have had to defer their enrollment by an entire semester because they scheduled their interview too late and encountered unexpected processing delays. My guidance is simple. Schedule your interview as early as the 120-day window allows. This gives you a buffer for any complications and reduces the pressure you will feel going into that interview room. Now we arrive at the moment that causes the most anxiety for F-1 applicants: the visa interview itself. And I want to begin by telling you something that may seem counterintuitive. The interview is not designed to trick you. Consular officers are not looking for reasons to deny qualified students, but they are trained to identify applicants who do not meet the legal requirements, and they must make these decisions quickly, often in just 2 to 4 minutes per applicant. Understanding what the officer is actually evaluating will fundamentally change how you prepare. There are 3 core questions that every F-1 interview is designed to answer. First, is this applicant a genuine student with a clear academic purpose? Second, does this applicant have the financial resources to complete their program without unauthorized employment? And third, does this applicant have strong ties to their home country that will compel them to return after graduation? Let us address each of these in depth. The first question, whether you are a genuine student, is assessed through your knowledge of your program, your university, and your academic goals. You should be able to explain why you chose your specific school and program without hesitation. If you are studying computer science at a particular university, know the name of the department, know what aspects of the curriculum attracted you, and know how this program fits into your longer-term professional goals. Vague answers like, "I heard it is a good school," or "My agent recommended it," immediately suggest that you are not genuinely invested in this educational opportunity. But this is where many applicants go wrong. They prepare scripted, memorized answers that sound rehearsed and inauthentic. Consular officers conduct dozens of interviews every day. They can recognize a rehearsed response within seconds. What they want to hear is genuine knowledge and genuine enthusiasm. Study your program not to memorize facts, but to genuinely understand what you are about to study and why it matters to you. The second area of evaluation is financial capacity. The consular officer needs to see clear evidence that you or your sponsor can afford tuition, living expenses, and incidental costs for the duration of your program. Your I-20 lists the estimated annual cost of attendance, and you should have documentation showing that funds are available to cover at least the first year, with a credible explanation for how future years will be funded. Common financial documents include bank statements, tax returns, employment letters, and property ownership documents if assets are being used to demonstrate financial stability. If a family member is sponsoring you, bring an affidavit of support along with evidence of their income and assets. One mistake I see frequently is applicants bringing large sums of money that appear suddenly in their bank account shortly before the interview. This raises immediate questions about the legitimacy of those funds. Consular officers are trained to identify accounts that have been artificially inflated. Consistent documented financial history is far more persuasive than a large but unexplained balance. If you have received a scholarship, fellowship, or assistantship, bring official documentation of this funding. Scholarships significantly strengthen your application because they demonstrate that you have been evaluated and selected based on merit, and they reduce the financial burden you represent. The third and most frequently failed area is demonstrating ties to your home country. And I want to be very direct about this. This is where most denials under Section 214B originate. The consular officer must be convinced that you have compelling reasons to return home after completing your degree. These ties can be economic, familial, professional, or a combination of all three. Economic ties might include a family business you are expected to join, property you own, or professional opportunities that are specifically available in your home country. Familial ties might include dependent family members, aging parents who rely on your support, or significant family responsibilities that require your presence. Professional ties might include job offers contingent on completing your degree, internship relationships with domestic companies, or specific industries in your home country where your skills will be in demand. What does not work is claiming that you will return simply because the law requires it or because you love your country. These statements, while sincere, do not provide concrete evidence. You need to paint a clear picture of the life that awaits you when you return, a life that is specific, tangible, and more compelling than the prospect of remaining in the United States. And here is something that later in this video, we will connect to your overall strategy. The way you describe your future during the interview must be completely consistent with the career goals you list on your DS-160 and the academic trajectory suggested by your program choice. Any inconsistency between these elements can lead to a denial. Let us now discuss what happens on the day of your interview and how small details can influence the outcome. Arrive at the embassy early, dressed professionally but not ostentatiously. Bring your documents organized in a clear, logical order. Your passport, DS-160 confirmation, I-20, SEVIS fee receipt, financial documents, and academic records should all be easily accessible. You will likely not need to show every document you bring, but having them ready demonstrates preparation and organization. When you are called to the interview window, greet the officer politely and make eye contact. Answer questions directly and confidently, but do not volunteer information that was not requested. One of the most common mistakes is over-explaining. If the officer asks how long your program is, the answer is 2 years or 4 years, not a detailed explanation of your entire academic plan. Keep your responses concise, accurate, and relevant. If you are asked a question you do not understand, it is completely acceptable to ask for clarification. It is far better to request clarification than to answer a question you misunderstood. And if you do not know the answer to a factual question about your program, be honest. Pretending to know something you do not is far more damaging than admitting uncertainty. Now, let us discuss what happens if your visa is approved. The officer will retain your passport, and your visa will be printed and returned to you, typically within a few days to a week, depending on the embassy. Once you receive your visa, you can begin making travel arrangements. Remember, you cannot enter the United States more than 30 days before your program start date. But what if your visa is denied? This is the outcome that causes the most fear, and I want to address it directly. A denial under Section 214B means the officer was not convinced that you overcame the presumption of immigrant intent. This is not a permanent ban. You are legally permitted to reapply at any time. However, reapplying without changing your circumstances or addressing the specific weaknesses in your original application will likely result in the same outcome. If you are denied, request any documentation the embassy can provide about the reason, and carefully evaluate where your application fell short before attempting again. At this point, I want to discuss who is most affected by common F-1 visa complications and what specific risk factors applicants should be aware of. Applicants from countries with historically high overstay rates face additional scrutiny. This is not a reflection of individual character, but a statistical reality that consular officers are required to consider. If you are from a country where many previous visa holders have remained in the United States beyond their authorized stay, you will need to present particularly strong evidence of ties to your home country. Applicants with limited financial resources or inconsistent funding documentation face heightened risk. If the officer is not convinced that you can complete your program without working illegally, your application will be denied. Applicants pursuing programs that are not clearly connected to career opportunities in their home country also face additional questions. If you are studying a field that has limited application outside the United States, you need to clearly articulate how you will use this education when you return. And finally, applicants who have previously been denied entry to the United States, overstayed a prior visa, or had any prior immigration violations face significant obstacles that may require professional legal guidance to address. As we approach the conclusion of this video, I want to leave you with practical guidance that does not cross into legal advice, but reflects the awareness that successful applicants typically demonstrate. Begin your preparation early. The most successful F1 applicants treat the visa process with the same seriousness they applied to their academic admissions. They research their program thoroughly, organize their financial documentation months in advance, and thoughtfully consider how they will articulate their ties to their home country. Practice your interview responses with a trusted friend or family member, not to memorize scripts, but to become comfortable discussing your plans naturally and confidently. The goal is to sound like yourself, not like someone who has prepared answers for an interrogation. Understand that the consular officer is not your adversary. They are doing a job that requires them to make difficult decisions quickly. Your task is to make their job easier by presenting a clear, consistent, and credible case that you are a genuine student who will return home after completing your education. And perhaps most importantly, do not let anxiety overwhelm your preparation. The vast majority of qualified applicants are approved. If you have a legitimate academic purpose, genuine financial support, and real ties to your home country, the interview is simply your opportunity to demonstrate what is already true. To summarize the key points from today's video. First, the presumption of immigrant intent is the legal framework that governs every F1 decision. Your job is to prove you intend to return home. Second, consistency is critical. Your DS-160, your documents, and your interview answers must all tell the same story. Third, financial documentation must show stable, verifiable, and sufficient resources to cover your education without unauthorized work. And fourth, your ties to your home country must be specific, tangible, and compelling, not abstract statements about patriotism or legal obligation. If this video has helped clarify the F1 visa process, please subscribe to this channel for ongoing immigration updates. New policies and processing changes occur frequently, and staying informed is one of the most important things you can do to protect your status. In our next video, we will be covering what happens after you enter the United States on an F1 visa, including maintaining status, work authorization options, and the common mistakes that lead students to fall out of status without realizing it. Thank you for watching, and I wish you every success in your academic journey.